Firstly, good afternoon and welcome. Delighted to have Martin back on one of our webinars. I'm pretty confident everybody knows Martin, but Martin is the ex-CEO of Unipol and a well-known and respected commentator on all things student accommodation. So one of the things that I've been quizzing Martin about for longer than I care to remember now is how is PBSA going to be treated? So it was originally the question I was posing with renters reform, and there were various, not from Martin, but various people going, oh, well, it's all sorted, don't worry. And I'm thinking, oh, this still doesn't sound quite sorted. So I was aware that Martin was still doing a lot of work into this really important area. So I'm really pleased that he's agreed to join us today. So the plan is that Martin's going to give you a update. So we've got some updated information to go through, and then there'll be some time for questions afterwards. The session is recorded as well, so we'll be sending it round afterwards. So yeah, all good. Without any further ado, thanks again, Martin, for joining us, and I'm going to hand over to you.
Thanks, Nick. Thanks very much. And it's good to do this second briefing. Follows on from one I did earlier, where I think we packed away PBSA in one slide. I mean, today is the last day of the report stage in the House of Lords. I doubt if anything spectacular is going to happen there, although the very last amendment to be discussed is government amendment relating to this issue. So I'll just tell you when that is, but I'm assuming that will be passed. And I was going to take this from the bottom, really, because I think there are a lot of people who know probably what I'm going to say, but there may be a few people who haven't quite strung it all together in terms of what's going on. And that included the government, by the way, who said, oh, yes, well, we're just going to exempt PBSA one way or another, very early on, without really thinking about how that might happen. A lot of this stuff has happened quite recently. So I'm now going to share the screen. That's the theory anyway. And just put this into the right format. Okay. Looking at purpose-built accommodation, PBSA in the jargon, just a reminder, about 58% of student accommodation is PBSA. 24% are in universities' own beds, so they would fall outside of the Renters' Rights Act anyway. 58% are direct let, so that's what we're talking about today. And those 18% which are in partnerships, their exact status will depend on how those partnerships work. And very early on, as I mentioned, under the Renters Reform Bill, so we're going back to the previous government, it was made clear that PBSA will be treated differently from off-street housing, and the current government has followed that through. So it's worth just looking at this, how it works, because universities, I've said I've always, but I've only tracked it back to the Rent Act 1977. It may go back before then, but I can't work out if it did. They've always been treated differently from private sector providers, and that was achieved by giving them what's called specified status. And that was granted through the snappily entitled Paragraph 8, Schedule 1 to the Housing Act 1988, lettings to students. And what that effectively meant was that they issued common law tenancies rather than assured tenancies. So when you look at things like deposit protection and so on, that all related to assured tenancies. And because they had common law tenancies, they were therefore not affected by that. And of course, they wouldn't be affected by the Renters' Rights Act, because that's, again, assured tenancies. The government took the view that because PBSA was signed up to a government-approved code that had been seen to work over the last 20 years, and I think that track record was important, those members of the code would have specified status extended to them. I think there was a certain amount of saying, well, the difference between a university hall of residence and a private sector hall of residence is really leveled, and it made sense to look at them both in the same frame. And there are many iterations of why PBSA and off-street landlords are being treated differently. And I know that off-street landlords are saying, well, what's so special about this? But just to give you the latest quote, which was going back a week or so, 2 weeks to 1st of July, Baroness Taylor, who's leading for the government and the Lords Committee report stage, said we've exempted this sector from the protections of the assured tenancy system because we're satisfied that the Unipol codes of management practice provide an alternative route to ensuring that tenancies are of a high standard. There is no such code for private student landlords, and it would be wrong to mirror that exemption, right? So that's about track record. And therefore extending that specified status, as I say, means that common law tenancies are issued. And as the Renters' Rights Act primarily deals with assured tenancies, and PBSA tenancies won't be assured, then the Act's provisions won't apply to them. And that will include the landlord portal or database. It's also going to include the decent home standard. And if you look at the initial consultation document that the government issued a couple of days ago on the decent home standard, you may be glad that PBSA has been exempted from that. Even though within the Act there's the ability to bring them in, the government has said they do not intend to do that. Now, specified status isn't a blank check, as it were, so it relies on a few conditions. So a student must be pursuing or intending to pursue a course of study, and they must be doing that at a specified educational institution. So what's a specified educational institution? Well, you can dig into the increasingly obscure Assured and Protected Tenancies Letting to Students Regulations 1988, and that will tell you what they are. And that's any university or university college or any constituent college, school or hall of another institution of a university. So basically a university and all their offshoots. Any other institution that provides further education or higher education which is publicly funded. And housing associations also have a specified status, together with a very few bodies listed in Schedule 1 and 2 to the regulation. So there are some oddities. So Good Enough College, I don't know whether they're on the call today, and International Student House are both specified specifically under Schedule 1, but there otherwise is not a list of specified institutions. So you have to work out that they're the university, they're an FE, they're publicly funded, or they are on what is quite a short list. And that is being built into the bill, and it's there under clause 33, which specifies a member of a specified housing management code of practice, right? And then who is allowed to join? So a person appointed to act on the landlord's behalf in respect to the tenancy, or a person appointed to discharge management functions in respect to the building, right? So quite a wide definition. So if you're managing the building, you will be able to join because you are regarded as a member. You'll be allowed to join as a member of a specified housing management code. I should just say there's quite a bit of trouble over all this because the government thought it would be very simple to define who should join the code by saying, oh, it's the person who gets the rent. And in the off-street sector, that's probably quite a good way of doing it, but it's not a good way of doing it when you've got very complex financial arrangements, as you have in PBSA. Just to remind you, there are 3 approved codes, and they're approved under Section 233 of the Housing Act. There's this, they've all got long titles, but there's effectively the one by the Unipol and one for student accommodation not managed and controlled by educational institutions. And then there's another code which are managed and controlled by educational institutions. And there's the university's UK Guild HE Accommodation Code of Practice for Student Housing, which is for the same area, it's for university housing. I would just make the point that although the government said they were going to level the playing field between the private sector and educational institutions, it's not quite level because the 2 educational codes can apply to smaller off-street properties in certain circumstances. And the details of that are within each code. And in that respect, they are not the same, right? So universities with smaller off-street houses that they own or which they have got on longer lease will fall outside of the Renters Reform Act. So So that's the government definition. So that's the first two hurdles, as it were. Specified institution, are you actually managing the building? But it's also important to understand that if we're looking at the private sector code, that the code itself has a criteria for membership. So it's a two-tier process. This is the second hurdle. And those criteria are fairly straightforward. And that's you have to have a larger development where 15 students or more live in one building in rooms off a central corridor, in cluster flats or in self-contained flats, right? So that's the 15 rule. It's been around since 2005, and that's one criteria. And code membership is open to those managing and controlling larger developments for student accommodation. And that's, I'll be precise about this because it is in the code. It's the case where a landlord of a residential property or any person who discharges management functions in respect of such a property. And for that purpose, managing functions includes functions with respect to the provision of services, repair, maintenance, improvement, or insurance of such property, right? So that mirrors what's in the code, and that mirrors what's in the bill. There's also the point that a member must have the ability to ensure that they're in a position to fulfill all the obligations contained in the code. So you can't just be responsible for bits of a building. And there can only be one code member managing and controlling a given building. So you couldn't split a building into individual flats and then have lots and lots of members of the code. So responsibilities within a building can't be divided. And so by fulfilling those conditions, private sector PBSA can be members of an approved code. Because they're members of an approved code, they will issue common law tenancies and be exempt from the provisions of the Act, right? So that's that circle. Just worth noting, by the way, that although we're using the phrase PBSA, that is nowhere to be seen in the legislation. It's not in the Act or the bill, and it's not in the National Code. And the term used is larger student developments, right? I have heard people saying, oh, we really ought to define purpose-built student accommodation. And I can promise you that would be a gigantic mistake, because whatever you define today, and this would fall into primary legislation if it was in the bill, will be out of date in 5 years' time. And we can already see all kinds of innovative new developments appearing on the horizon, mirroring a little bit some of the progress in build to rent, or in co-living, which also applies to students in certain circumstances, where that would fall out of a definition that we did a couple of years ago. At present, PBSA providers issue assured short-hold tenancies. And the bill made it clear that only tenancies granted after specified status had been granted will be common law tenancies, right? So there is a transitional phase, and I think the MHCLG underestimated the effect of that transitional phase. So briefly, when the new assured tenancy regime comes in under the Act, and we'll talk about timing a bit later on, but the assured tenancy will not, an assured short-hold tenancy will transfer into an assured tenancy. And so momentarily those people will fall under the Act. And that's the transitional phase. Now, originally, MHCLG said, well, we don't need to make any special arrangements for this. But what it would have meant would be, first of all, the students had security of tenure, just like under the Act when it comes in, until they gave 2 months' notice. They could give 2 months' notice and leave at any stage. Rent payments would have been changed and restricted to 4 weeks in advance. And clauses relating to pets and anti-discrimination clauses would apply. The Ombudsman Service and the landlord database would apply, but they are not going to be up and running by the time the transitional phase ends. So that wasn't the problem. But really, that would have been a monumental pain to implement for a very short period of time. The government said, well, we're still being nice to students because people can use the new repossession ground 4A, so they can give notice, and that will maintain the academic cycle. So we don't know what the problem is with that transitional phase. Well, one of the problems is that there's 78,000 studios, and they would have fallen out of grounds 4A at that time. And so people in studios could really have come and gone whenever they want, and it wouldn't have applied. And removing those from the supply, as it may have had the effect of doing, would have been quite serious. So the government had a thought about that, and they accepted that that was problematic. And so there are some special concessions for that transitional phase for code members. So first of all, the property won't have to be an HMO to use ground 4A possession, so it will apply to the whole stock. You'll be able to give notice of repossession to take effect not just between July and September. You can do it any time during the year. You'll recall under the bill, there's a provision that if you sign the tenancy more than 6 months in advance, then you don't have access to ground 4A. That's not going to apply. And the other thing was, at the time of signing the contract, the tenant had to be told that you intended to use ground 4A. That is not going to be necessary. So in fact, what will happen is assured short-hold tenancies will turn into assured tenancies, and then landlords of PBSA have got 28 days notice of intention to seek repossession. So most people will then serve a notice towards the end of the year saying, well, we're going to seek repossession on the 30th of June, on the 1st of September, or whatever. It's still a pain. It's still not quite what the government said it was going to do. And they'll cause some rental loss. So students can give 2 months notice at that stage. So fixed term contract doesn't apply in that sense. Rental payments, we're still seeing what happens on that. I think the position will be that tenants can insist on only paying 4 weeks in advance, but if they've agreed to pay up front and they're not insisting they want a shorter period, then they will continue paying as they normally would. And there are some short-term issues about planning compliance. So you could say, well, we're only supposed to be housing students, and this person is refusing to go, and you know they're not a student. That won't last for long, because you can issue repossession on ground 4A while they are a student, right? So that will be a short period of time. I mean, the big question is so how long is the transitional period? And that depends on when the Act will take effect. So the government's original target was Easter 2025. So you don't need to be a genius to work out they failed that. They then wanted to get the bill through the remaining stages of the parliamentary process, the Lords report stage, consideration of final amendments, royal assent before the summer recess, which is coming up soon on the 22nd of July. But the reality of it is that problems have occurred. So the Lords report stage is later than was originally planned. So the 1st, 7th and 15th of July. And that has two effects. One, it drives it to the end of the parliamentary period of sitting. But the other reason is there was about a 6-week gap between the Commons and the Lords, during which a lot of amendments have accumulated. So I haven't worked out how many there are. I'm told some from beginning to end of this process, somewhere around 400. And by the way, the government has suffered some defeats on amendments in the Lords, none in the Commons, and that's affecting students. We'll talk a little bit about that later. Pet deposits, you may have come across, joint tenancies, carers, agricultural workers. And either the government can choose to accept that, in which case they'll just do the third reading in the Commons, or they may say we're not willing to accept that, in which case it will have to be sent back to the Lords for further consideration. So that will take longer. Now you can work out if it's going to leave the report stage today, it's not going to be finished by the 22nd. And in fact, the government have set a provisional date for the third reading of the bill on the 21st of July. So just one day between the summer break. And by the way, that third reading of the bill may well still see some amendments being made. So if someone says, well, this wasn't a previous amendment and it's just occurred to me, and the government have agreed to look at this and they haven't done, you can table amendments at the third reading. And I think there probably will be the odd amendment tabled. So after that, it needs to go back to the House of Commons, consideration of the amendments, and then back to the House of Lords. So the earliest the bill can be sent to the Commons is sometime between the 1st and the 16th of September. I think it's likely that it won't be sent back to the Commons at that stage, but it may be. And then there's a 2-week gap for the party conferences. And just so you know, the procedure, royal assent is normally 2 weeks after passing the third reading in the Commons, and all acts come into force 2 months after assent. So and we know that this act is going to be phased in. Because the government said that. And by the way, it's going to be phased in because the Decent Home Standard and the landlord database and a whole raft of stuff is not yet finalised. And that will be dealt with by secondary legislation following consultation. So it will be phased in. Abolition of Section 21, which is the manifesto commitment, will clearly be one of the first things that gets phased in. It's possible if you think there's going to be some activity between the 1st and the 1st and the 14th of September, it will come into effect in late March. But my guess is that June 26 is more likely in terms of tenure change. So the lettings for 2026-7 will be affected, but already lawyers are looking at the possibility of introducing a contractual term for PBSA landlords on lettings, saying in the event the landlord becomes specified, then the common law terms will apply from that date. And that, I think, will be valid because you knew up front what was going on. And the tenancy won't technically have started until after specification. So you may find that the shift from current tenancies, from assured short-hold tenancies to assured tenancies, may well be fairly contained between June and September. There's also the point that you can serve a notice under Section 21 within the first 3 months of the Act coming into force, and that will also still be valid. I had some doubts about that, but since it's now appeared as valid on the Shelter website, I think we can assume that that is fairly cast iron. So in theory, you can give notice under the existing tenancy 3 months from the beginning of the Act, which would cover the June to September space. Successful amendments, well, just worth spending a second on the government's defeat by Lord Willett, which said that Ground 4A should apply to all student properties, not just HMOs. I think there's a 50-50 chance the government will accept that, actually. If you remember, it was accepted by Gove and the previous Rental Reform Act. But the government have said they didn't want to do that, so we'll see. You may have heard about, it doesn't affect PBSA, but you've heard about an additional 3 weeks deposit can be levied when the tenant has a pet. That's something the government didn't want in the bill. And there are some really complicated changes to joint tenancy arrangements for assured tenancies, which I think probably will bear further legal examination because they strike me as a bit fraught. So it wouldn't surprise me if that amendment needs to be re-amended after people have done a bit more work on it. So that's the bill. And now it's worth just looking at what people are being asked to sign up to. And that's the National Code. And the National Code has undergone a revision. You may have been involved in the public consultation phase of this, but that consultation is now closed. So the code that Unipol has put together will go in its current form for approval to the government. It's likely that the government will have another 14-day consultation period just to put themselves entirely in the clear, in which case you could still make representations. But in general, I think the proposed code is fairly solid. And it's important to see the changes that have been made in the wider policy context of this government's policy initiative. And they've summarised that as rebalancing the rights between landlords and tenants. And that's a much stronger message than the previous bill under Michael Gove. And he said the bill was simply to end no-fault evictions. So there's a bit more going on here. And I think you can see that in terms of some of the changes that have been made between the reform bill and the rights bill. So the new code's been amended to reflect definition of managers that's now going to be in the Act to maintain consistency. Some procedures have been clarified so that we've got not many people in the waiting room. So in general, you're either a member or you're not. And if you build a new building or you buy a new building and so on, it's much sharper in terms of what's in your portfolio and what can be covered by specified status. And the complaints process has undergone a bit of a spring clean, and that's the first time that's been rewritten since 2005. So there has been some greater flexibility introduced into common law tenancies. So the position is now that people will be able to give 4 weeks notice. Students will be able to give 4 weeks notice if they've withdrawn from or being excluded from or been refused admission to their institution of study, or if they've been absent for more than 60 days due to illness. That's, by the way, the definition from the Student Loans Company of when people are leaving their studies for illness, either temporarily or permanently. So that's been regularized. And that there was a big argument when we were doing this about whether that should be 4 weeks or 8 weeks, but the view has been taken, supported by some of the larger members, that 4 weeks is better with the written notice giving evidence up front, right? So if you're saying, I'm leaving university and I want to give 4 weeks notice, you have to provide proof of that up front, as opposed to a longer period where you can produce the proof at any stage during a longer period. So it's much, much easier. And in the case of illness, you get a confirming letter from the education institution, and they will need to provide that to the Student Loans Company anyway. Now, you could say, well, why is that greater flexibility being introduced? And it was interesting that Baroness Taylor, in a debate on the 7th, was asked, why can't off-street properties have fixed-term tenancies? And she said, in the current system of fixed-term tenancies, we often hear of students who've dropped out of university but are still obliged to pay rent for their accommodation. I could mention some examples, but it's not appropriate to do so. And that's why they can't have fixed-term tenancies. So you could see there would be a real tension if a student started complaining that if I lived in the property across the road, I would be able to leave my tenancy, but in this building, I can't. And in general, those people who leave tend to leave fairly early on, in which case most suppliers succeed in renting the room. But I think PBSA suppliers have got to see the way the wind is blowing on this. And if you're going to have a secure system of effectively exemption from what is a fairly significant act, then it helps to get rid of some obvious problems that would create really quite a lot of publicity and bad news for suppliers. So that's why that's been changed. Some of this is fairly straightforward. If a person dies, then you can bring the tenancy to an end. The guarantor ends. Now, almost no providers do anything other than this, but it hasn't been in the code. So what it says is, on death, the arrangements effectively end. There are some other clauses here about how members are allowed to clear rooms and so on, and they should be helpful, because we have had there have been some instances under the code where people's belongings and their estate in land, which is what a tenancy is, have fallen under a very bureaucratic probate system, thereby freezing effectively a room for a very long period of time. Deposit protection doesn't apply to common law tenancies, and there's therefore no legal obligation to protect them, but that obligation has been maintained. If you could imagine a PBSA provider going into liquidation and students being unsecured creditors, which almost happened just before tenancy protection when Opal went into liquidation, that would be bad news. And so the code effectively says people will protect those voluntarily. They'll already be protecting them under the current legislation, so no big changes there really. And just to finish with, I think this is an important moment for PBSA providers. There's some inconvenience over the transitional period. I think that's regrettable. And if we'd looked at it a bit earlier, as some of us wanted to, about 3 years ago, that could have probably been avoided. But it is what it is now. There's a big division now, a fork in the road on student renters' rights between PBSA and off-street properties. But a little bit less of a fork than there would have been if the code hadn't been revised. There's some increased but fairly limited tenure flexibility. But I think I would say to PBSA providers that the voluntary nature of being a member of an approved code, and people say, oh, well, now you've got to join, but you really haven't actually. It's voluntary. The consequences of not joining have become more problematic. But it is a voluntary membership. And the fact is that for the last 20 years, people have joined voluntarily. And they've abided by additional extra legislative provision over a decent period of time. And that is the reason that PBSA is being treated more favourably by the government, because they accept that the protections introduced under the Act are not going to be required by the vast majority of PBSA providers. So this is a vote of confidence in a sector that's been pro-student and which has treated students fairly over a period of time. And that's, so no one's doing anybody any favours. It's a recognition of track record. Okay, thanks very much. So that's what I have to say. I'm very happy to take questions and comments.
Brilliant. Thank you very much, Martin. That was superb. Thanks a lot. We have had a few questions come in. So one is, there's a very specific question. It is, if a PBSA is removed from the Unipol code due to fire stopping issues or other issues, would they still be exempt due to the 15 rule? So I think this is where you're referring to the kind of minimum size of a PBSA, effectively.
Sorry, I've lost you on the minimum size. Sorry.
So I think the question is I think boils down to if somebody is removed from the Unipol ANUC code, would they still have these exemptions or not?
No, they won't. I mean, their current common law tenancies will continue until they expire, but they will not be allowed to issue new common law tenancies. But I think it's just worth, saying a few things about expulsion. Expulsion under the code is really reserved for very considerable non-compliance, right? What people are talking about on fire stopping is the Building Safety Act in the main and remediations, right? So I think there are some new clauses in the code relating to that, but it's really clear that building remediation is a matter for the building safety regulator, right? The aspects that the code deals with are about communicating with tenants and telling them what's going on and trying to minimize their inconvenience, right? They're the aspects. So, if you just said, well, it's just tough that we boarded up your window for a year. I know we didn't tell you, and it's a bit colder than it would be. And I'm sorry, we sold you this room as having sweeping views of the city, and now you're sat in darkness. You can see that would be in breach of the code. What won't be in breach of the code is somebody coming in and saying you should do this remediation faster or in a different way, because that is a matter for the building safety regulator. That's not a matter for the code. So expulsions, you can see them coming, and it's in no one's interest to, as it were, say, oh, this fire point was out of operation, so we're going to throw you out, and then you'll have to reapply, and then you might come back in again. We have made it's become much easier to add buildings. So if you looked at what happened with new buildings under the current code, they have to be verified and inspected before they join your portfolio as a member. Now, that would clearly cause some problems because you'd say, well, we have two buildings next to each other. This is an old building that's already in the code. This is a new building and we're waiting 6 months to have it properly verified. And therefore you'll all be on assured tenancies and that building will fall under the Act. That will clearly cause more problems than it's worth. So as soon as you add a building, it will be part of your portfolio and it will be specified. So the only people who will be affected in terms of tenure is if someone is actually expelled. And,
Okay.
and I would just remind people that that isn't at the whim of Unipol or ANAC or whatever. That goes through a tribunal process, which is chaired by an independent person, and the tribunal itself is independent. And any supplier who felt they were being unjustly treated has a right to that hearing. So they have their day in court. So it's not and you can't just say, well, we have some concerns. You have to breach the code in specifics. So I think people are more worried about that than they should be.
Okay.
And incidentally, I think most people comply with the code, by the way. I don't think that's a soft line. Most people accept things that they've got wrong and they put them right. And that's how the verification process works. And that's a fairly productive process.
Good. Okay. Another question, or it's more of a comment really, and I think I know where your thoughts lie on this, but I'm going to ask it because someone else has asked it. So we talked about, or you mentioned sort of that fairness or balancing in, I think it's probably a landlord who's raised the point that, look, we've got to adhere to sort of licensing, as a HMO, which is as rigorous or perhaps more rigorous than the code. So how's it fair that, there isn't an exemption for HMOs, given the hoops relatively that they have to jump through to kind of on the licensing side.
Well, licensing is a tricky area, and you may know that Lord Best put forward an amendment to say that specified bodies should be exempted from licensing. Universities are, by the way. So if universities have to join a recognised government-approved code to be exempt from licensing. It's not about their specified status. I mean, my view is that licensing is not terribly appropriate for large buildings, and that now we've got the Building Safety Act and the Fire Safety Act. They're a separate regulation affecting those. So I think it is very different from a small house, to be honest. Also, under the current licensing regime, and of course, converted buildings are licensable in PBSA, and older buildings in some cases. You tend to find the local authority gives you a license per flat, whereas actually most of the serious health and safety risks relate to the whole building. And that's what the building safety regulator was appointed to do, to take what's called a whole building approach. So the idea that if you took a PBSA building and you've got flats of 2, 3, 4, 5 or whatever, you could imagine, oh, well, certain flats on the floors above 3 will be licensable, but certain won't, and you pepper pot licensing. Not much of PBSA is licensed, and I think the interplay between licensing and accreditation is interesting. I would hope. I think it's a pity because I mean, Lord Best is a serious player here, right? And the government have accepted. He's probably the only person the government have accepted some amendments from and have adopted them as their own. I just think it's incredibly bad timing because the government itself is having real problems with the building safety regulator, and you'll know that it's going to move from the HSE into a separate organisation because of the delays. So in the middle of this, somebody then comes in and says we should get rid of licensing. So what the government's done is receded to its position, which is saying we don't want to look at licensing at the moment because it may impact on how we're going to deal with the Building Safety Act. And that's a bit of a lazy excuse. But at the moment, I think that carries a little bit of weight in the context of all the change that's going on. I mean, my view is that Lord Best will come back and have another bite at the cherry. But I mean, it's interesting because there's an amendment that's on today, actually, one of the amendments tabled today, that says local authorities should be allowed to raise housing standards by setting licensing conditions. And it's interesting, isn't it? Because I thought that's what had been happening for about 10 years. Um, so, this is a licensing is this act kind of ignores licensing, um, and purposefully ignores licensing. And, the landlord database, if it's going to start saying, oh, you have to have certain things, if you ask the government, how's that going to overlap with licensing? The answer is that's totally different.
Okay.
So they are trying to keep all those things separate. I think it's a mistake. It would have been nice to have a more holistic approach.
Good. Okay. There's a couple of questions. I'm not sure whether you can deal with them or not, but they've been raised. One is, I suppose, in terms of the codes, do we anticipate a lot more people joining, and hence is the capacity to effectively process them, and also the cost. So there is a cost involved, isn't there? So I'm not sure if this is something you want to deal with or whether we
Well, I can comment. I mean, one is that about 95% of all PBSA is already in the codes, right?
yeah.
So if you look at Cushman and Wakefield's estimate of the whole PBSA sector, and they do that by effectively monitoring all the buildings, there's about 5% that are not members of the code. And when you look at that 5%, about half of those are mixed occupancy. So they're really built to rent, where you've perhaps got 40% students. I should just mention that people say, well, why can't that join the code? And the answer is because the building has to be predominantly occupied by students, right? So I just didn't mention it in the conditions because we're talking here about student accommodation, so it's helpful to have students. But you couldn't put 16 students in a building for 500 and claim that you could join the code and become specified. I think the only new people who join will be new investors, who are starting from scratch. Somebody will build a building of 400 bed spaces and apply to join the code. They will be a bit frustrated that they have to go through the full verification process before they're members. But hey, who are they? There's not necessarily a track record, and they're new, so they must expect to, as it were, get checked on. And I know some people have said, well, isn't that discouraging new entrants to the sector? But I just remind you that all other members of the code have gone through that system, right? No one's got a buy, to say, well, you look nice, and the building looks lovely. So I'm sure you know how to run it, and I'm sure it'll all be lovely. And and Unipol shouldn't take that risk. And the other category of buildings will be very small buildings where, and that I think there's some evidence that that's happening, where people just haven't bothered to join the code because it's quite onerous. And, I'm a landlord, I've got 20 small houses and a building with 30 students in it in flats. Now, people may now think, well, it is now well worth me joining for that extra, for those 30 beds. So they'll be new, and they will need some assistance in meeting the conditions of the code, because some people may be managing those more like a large HMO, and actually PBSA is a different management methodology. Cost, well, I mean, I'm not chief executive of Unipol anymore, but I'd just point out that this change has been in the pipeline for the last year or so. As far as I'm aware, fees have gone up about in line with inflation recently. And actually, I would just remind people that Unipol is in fact a charity, right? So, it's not going to say, oh, here's a great opportunity to make loads and loads of money. That will not be the impetus from Unipol. I mean, it was interesting because I was talking to someone, a very prominent consultant, who said, well, if you were a private sector organization, Martin, what you'd do is you'd work out what this is worth in monetary terms, right? Because you can have fixed term contracts, you don't have to do all this extra bureaucracy. You'd work that out as an opportunity cost, and then you'd increase the code fees to 90% of that cost because it's still worth joining for the 10%. Right. So I could reassure people, even from outside of Unipol, that is not the approach that's being taken. And, I don't think people should be too worried about that. I also think, by the way, that the government will keep an eye on that, right? Um, this is not because it can be shown really that code members roughly pay for what they get. This is not a commercial service, and it's not subject to procurement. Right.
Okay,
So if that changed, it would put a very different slant on things.
good. Okay, so a couple more of final points to sort of finish on. So in terms of your view on timings, you're thinking probably June, really.
Yeah, I think that is my view. Yeah,
Yeah, because then the early days around Easter, so that ability for students to give 2 months' notice would have an implication on sort of
yeah,
live tenancies for next year. But you're thinking, well, it's probably going to be towards the end of the tenancy anyway, so it's not.
yeah. I think it is fairly limited, actually.
Yeah.
Yeah.
Okay.
I think the timing of the bill, yeah, I mean, if it was coming in to the government's timetable originally, so the act came in and was approved by Easter, you'd be looking at the kind of provisions for Section 21 coming in about October. That would affect a whole year's tenancy. I think this is coming in at the fag end of a tenancy, really. I mean, it will still be tedious. Well, and I think some students will find it hard hard to understand when they get told about this. They'll think, well, what's that about? I'm leaving anyway. So I think it will be puzzling. There is no advantage for international students in paying rent monthly, because a lot of those people pay currency charges per transaction. So if someone said, well, let's take Nigeria, where it's really expensive to transfer money. I mean, there's a fixed fee that can add about a third to the cost of your fees, actually. That's how big your academic fees, that's how big the fee is. If you said, well, they only want to pay monthly, so can I have a refund? That would have to be sent back to where it had come from under the money laundering regulation. So by the time you've got it back again, it's probably cost you a fortune. So I'm not sure that will happen either. There'll be the odd person who takes advantage of that momentary tenure flexibility, but I don't think it's that serious.
Okay, and then I think the last one just to touch on is this issue of specified status. So at
Yeah,
the beginning, you talked about specified institutions, and some of them are pretty obvious, aren't they, in terms of where they said, but there's no list, so there's no definitive list. So I think the area where that's going to create confusion, isn't it, is say language schools, for example, for sort of international students on a pathway. I know that in previous lives we sort of placed a lot of students like that in PBSA. So it may well be that some of those are actually institutions that are not specified.
yeah, I think that's a bit of a difficult area, and it's made slightly more difficult by the fact that, I mean, so these could be short lets, by the way, and short lets under the current legislation is a common law tenancy. But actually, one of the reforms in the Renters' Rights Act is to stop that and they become assured tenancies. So the test for a short let is whether, and I'll get the wording slightly wrong, but it's you'll see what I mean. It's whether it could be regarded as someone's main home.
Okay.
Right. So that will be the test. If it can't be regarded as someone's main home, you can issue a common law tenancy for those people anyway. So language schools over summer, that's fair. I think that's fairly
Yeah.
straightforward.
Okay.
There'll be common law tenancies. I mean, I think some language schools and some educational institutions may well be advised to look at applying for separate specified status as an educational body. There's right. So, and by the way, I just point out that's the Department for Education, not MHCLG. So you can write and you can say, I think we're a proper educational institution. This is our governance. We're solvent. We follow these regulations. We're British Council accredited, etc., etc. I think we'd like to be specified individually as an institution under the 1988 Housing Act. And I think some of those people will have a very good case for that. And although, and the term publicly funded may be quite interesting, because it won't mean that you get £1 from the local authority. Does it mean, what does that mean? So it wouldn't surprise me if some of those more reputable kind of language school plus colleges actually start looking at specified students and specified status, and whether the DFE starts doing a bit of work on that to make that easier. If you're in doubt, by the way, you can write to DFE and
Right.
say, does this person fall under a specified status?
Okay.
So you can go back to the originator of who decides and ask them. But it really wouldn't surprise me if you start getting some applications. The last application was 2013, by the way. So this is not a this has been fairly dormant for a while. But there are I mean, it's worth I suppose it's worth if you're a bit nerdish having a look at the two appendices and seeing who's in there. Appendix 2, which are housing associations, is quite a bit longer. And most people would say, oh yes, of course, yes, of course they would be specified and so on. So I don't think those institutions are automatically damned by that. I think there's a bit of, and by the way, if this is going to come in a year or so's time, they've got a year or so to do this. So, perhaps they ought to start looking at that. Or perhaps a PBSA provider dealing with a large
Yes.
language school that forms a significant part of their business might suggest to them they should apply for specified status individually
Yeah.
and assist them to do that, because it would make life easier.
Indeed. Martin, oh, hang on. There's one more question. Let me have a quick check. No, it was just somebody saying how useful it's been, and thank you. So I just wanted to reinforce that, Martin. Thanks ever so much for your time and just really detailed insight again, which is fantastic. So thanks for that. As I mentioned at the start of the session, I will be sharing the full video, so email it round as well as different bits of content from it. So thanks again. I'm going to press end on the webinar now, which will give us a fairly abrupt ending. So thanks everyone for joining us, and thanks again to Martin.